This is the American Law Network.
Live from Washington, D.C., and broadcast to more than 50 sites around the nation, the American Bar Association Section of Litigation and the ABA Division for Professional Education present Dealing with the S.O.B. Litigator. If you have questions for today's panelists, please call the number displayed on your screen. Today's moderator is Michael E. Tiger of the University of Texas Law School. Mr. Tiger is also chair-elect of the ABA Section of Litigation.
Welcome to the ABA Section of Litigation, Division of Professional Education program on dealing with the S.O.B. litigator. It is, of course, the obligation of every lawyer to represent her or his client with warm zeal. And Erskine, the celebrated 18th century advocate, is justly honored for having so far perturbed an English judge who was trying to override the rights of someone Erskine was representing as to have been provoked into comments that ring through the ages as a celebration of lawyers' independence. We're not talking about warm zeal today. That is the obligation of lawyers. Rather, we're focusing on those lawyers who, by bullying and dirty tricks, seek to bar the door to justice. We're talking about those lawyers who, by their sleaziness, seek to rob the adversary system of its wonder-working power to do equal justice between the rich and the poor, black and white, neighbor and stranger. We're not here to preach. Everybody knows the rules, and everybody knows that dirty tricks are wrong. Rather, we're here to present the quiet force of sound tactics. We have assembled an all-star cast of skilled and experienced men and women who are going to share with you practical thoughts on how to deal with the S.O.B. litigator. In the first panel, we're honored to begin Judge Jerry Buckmeyer of the United States District Court for the Northern District of Texas, the court that issued the Dondi Properties opinion that's reproduced in the materials. Judge Buckmeyer was appointed in 1979 and before that practiced for 21 years with the Dallas firm of Thompson & Knight, specializing in antitrust and general business litigation. He's a UT Law School graduate, chosen by the American Lawyer as the best district judge in the Fifth Circuit, and writes a monthly humor column for the Texas Bar and Dallas Bar publications. He sits in Dallas. To my immediate left is Diane Nast, a senior member of the firm of Cohn, Savett, Klein & Graff. She has a national practice in federal and state courts in commercial and complex litigation. She frequently teaches litigation tactics at ALI and ABA programs and is a member of the council, the governing body of the ABA Section of Litigation. Diane practices in Philadelphia. Next to Judge Buckmeyer, Steve Morris of Lionel, Sawyer & Collins, where he is a senior litigation partner. Steve is a member of the American Law Institute, co-author of the excellent materials on discovery abuse contained in the packet that everybody has, a member of the American College of Trial Lawyers, specializing in general civil litigation, complex cases. Steve is from Las Vegas. And finally, Michael Hyman, who as chair of this program has done more than anybody else to focus our attention on these problems, to pull together these materials, and to do the crucial planning. He's a partner in the Chicago, Illinois firm of Mutch, Schielis, Fried, Dennenberg, Anant, and Eiger, concentrating in class action and complex civil litigation. Mike is going to introduce our program.
Recently I heard about a law firm advertisement in which the lawyers, dressed in black leather, were pictured on imposing motorcycles. The copy read, "If you need a street fighter, call us." Our title, Dealing with the S.O.B. Litigator, is a biting and critical commentary about our profession. As a Chicago litigator concentrating in complex cases, I have too often come up against the obnoxious and contemptuous litigator. Many lawyers around the country feel that the profession is suffering from an erosion of cooperation between attorneys. an erosion of courtesy and civility, and an erosion of confidence that other attorneys will honor agreements. One of my objectives in developing this seminar was to provide a forum for lawyers to explore ways to inhibit and resist the behavior and tactics of the S.O.B. litigator. Dirty tricks, hostile aggression, hardball strategies, nastiness, arrogance, a no-holds-barred mentality plague the practice. Our goal is to improve the quality of lawyering and to reaffirm each lawyer's duty to be honest and forthright at all times to the court, to the public, and to the opposing parties. And now to our energetic and dynamic moderator, Michael E. Tiger.
When my colleagues heard I was going to be on a program about the S.O.B. litigator, they asked whether I was going to be an exhibit. And I said, no, I'm going to be the moderator. We've dealt with this problem of who they are and how they behave by having these dramatizations or vignettes. So let's roll the first vignette and observe an S.O.B. in action at the deposition.
This case happened several years ago. I was just out of law school, working for a small firm, getting my feet wet doing some of their smaller cases. We represented the former tenant in a landlord-tenant dispute. Nothing special. Now, most attorneys I've worked with have been okay. Some were tough, but they generally played by the rules. But opposing counsel on this case was a real jerk. He knew I was the new kid on the block, a woman, and he was intent on using every dirty trick in the book. I was deposing defendant's leasing agent, and even during the preliminaries, this S.O.B. was out for blood.
Mr. Swain, if at any time during this deposition you don't understand a question, just let me know.
He's not making agreements.
Is this an objection?
You bet it's an objection. You're not asking him to answer a question. You're asking him to make an agreement. If you got a question, ask it, but don't ask for an agreement.
Mr. Swain, are you saying that if you don't understand a question, you're not going to tell me that you don't understand the question?
He's not telling you anything. I'm telling you, he's not going to enter into any agreements. This is a deposition, lady, not let's make a deal. If you have a question, then ask it and stop wasting my time. And another thing, I don't like the way you set up this deposition. You set up this schedule without regard to my needs or my client's needs or anything
And this
else.
was only the beginning. He really went at it. This guy's middle name should be Obstruction.
Mr. Swain, have you taken any courses or received specialized training of any nature in the real estate area?
Object.
To what?
The form. The form is too general.
How is it too general?
Listen, I don't know what real estate area is. How's the witness going to know what it means? It's too general.
Well, you're not answering the question. He is.
No, little darling. I'm objecting for the record. I'm entitled to do it under the rules, and I'm making my objection right now.
That's fine. Let's proceed.
Do you understand the question?
No, I don't. I mean, there's a lot of different courses you can take.
I want to know if you've had any training in real estate other than your 2 years of college, or any classroom training in college or anywhere else.
Form, form, form. You're asking compound questions here. If you can understand it, then go ahead and answer.
Well, you've still got to be more specific, because I'm confused. I don't know what courses you're talking about. Do you mean a specific college or a business school, on the job, in person, through the mail? What?
All right, let's take it one at a time. Did you take any courses in college?
No.
Through the mail?
Sure.
What types of courses?
Writing courses.
Were they in any way connected to real estate?
What is connected with real estate? I mean, how to deal with people could be connected with real estate.
All right. Did you take a course teaching you how to conduct lease negotiations?
Yes.
Well, what type of courses were they?
What do you mean by courses? You mean accredited courses?
No, not necessarily. You said yes. Tell me what you were saying yes to.
Honey, he was saying yes to your question. Now, I know this is very difficult for you, and I'm trying to help you out as much as I can. And take it from me, you definitely need help. Now, let's move it. I don't want to be here until midnight, sweetheart.
Counsel, I don't need help from you, nor do I want help from you. I'm just trying to make sure that the witness understands the question, to make sure we're on the same wavelength.
Nobody is on your wavelength, little girl. You don't even know how to ask a proper question.
Did you ever discuss the terms of this lease with anyone employed at the EZ Company?
I may have.
Please answer yes or no.
The witness has answered the question.
With whom did you discuss the lease?
Well, I think that it was...
Just a moment. Object. The witness has already testified that the only thing he remembers talking about is paragraphs 3 and 4 with Mary Cameron.
With whom did you discuss the lease?
I discussed paragraphs 3 and 4 with Mary Cameron at EZ Company.
And with whom else did you discuss the lease?
I don't remember.
Diane, it's the morning before that deposition. The lawyer who's going to take it is in your office. What advice are you going to give her about how to avoid falling into that pit?
Well, I'm going to assume, first of all, that she has prepared, she's organized her materials, she's outlined her questions in some form so that she's not stabbing around. Even experienced lawyers do that, and I would certainly want to make certain that she had done that. I think probably the first thing would be don't argue with your opposing counsel. This vignette demonstrated her repeatedly getting into colloquies with him. You can't, a lawyer like that can't play his game unless somebody plays it with him. And she fell right into that trap and kept saying, what do you mean, and I didn't do that, and I don't need help, and so forth. My suggestion would be to her, if she gets involved in a situation like that, and he says something that she says, is there anything else? Is there anything else? And give him an opportunity to get all that on the record. It's not going to hurt her if that gets before a judge. That record will demonstrate very clearly what kind of tactics he was using. She doesn't have to respond in kind. She doesn't have to say anything. Just let him continue. I personally would ignore his gender remarks. I know that there are other people who feel you should take somebody on like that. I don't think you dignify those kind of comments by responding to them in kind. I think in terms of her questions, she really did need help asking questions. She didn't formulate simple questions. We always tell our young people, use simple questions, use words of one syllable, ask for one thing at a time. And with an obstructionist like he was intending to be, even though her questions were understandable if he wanted to understand them, she was using compound questions. He was using meaningless objections, but nonetheless, again, by the kind of questioning that she used, she's playing into his hands. So I would suggest that she not do that. She might also ask the reporter, when his obstructionist conduct became evident, to mark the questions that she might want to come back in. And I think that if a lawyer recognizes that a lawyer on the other side is having questions marked, that maybe that lawyer might be a little bit more careful with the idea that this transcript may well, in fact, end up in front of a judge or a jury.
And when you say mark the questions, all you need to do is turn to the reporter and say, would you mark that, please? The reporter will mark that place, makes it easier to find later. Right?
That's right.
Steve, what about you? What would you say to that lawyer?
Like when Diane said she assumed the lawyer who was going to take that deposition was prepared and had organized her questions, I would add to that I would have gone over those questions with the lawyer to ensure, rather than be assured, that the questions are straightforward, that they're simple, like Diane said they should be, and that they are not compound. There were a good number of questions in this excerpt, I think, that were too broad, compound. They were objectionable. I would reiterate what Diane says, and that is not to debate with an aggressively obnoxious person like this. That only encourages further tactics of that kind. You can say, as Diane suggested, something along these lines when the litigator has made his objection. Are you finished? Do you have any additional objections you wish to make before we go on, or some such thing as that? But I would err, if I erred at all in a response, on the side of saying little or as little as possible. The less you say in response to someone like this, the less encouragement that person has to keep up those tactics. And over time, who knows, the person may tire of that. But in any event, don't engage in conduct of like kind.
Judge Buckmeyer, obviously when a lawyer is sitting in a deposition like that, she or he must be thinking about the prospect of bringing this matter before the judge, making a record.
Correct.
What's your reading on what we just saw?
Well, not only bringing it before the judge, but also think about taking it before the jury. Can you imagine what that S.O.B. litigator would look like to the 12 people who were deciding that case? Witnesses' credibility, someone who doesn't know what real estate is, someone who doesn't know what courses means. So echo what has been said by two panelists. Don't get into a fight so you can use that for trial purposes. Also, eventually you are thinking about coming before me. Now, don't come before me with a 1-foot stack of papers that says a motion to compel answers to all of these questions. I'm going to immediately think I don't have time to read that, I've got other things to do. Or don't get into a battle with the other side, because it puts me in the position of hearing lawyers saying, well, he did it too or she did it too, and I'm probably going to cut the baby then and rule against someone who has a meritorious position.
Let me suggest we do this. I've got a script in front of me of what we just heard. Right from the opening gun, the lawyer did what I think all of us do in depositions. Said to the witness in a courteous tone of voice, if at any time you don't understand the question, please just let me know. At that point, opposing counsel said, he's not making any agreements. And then plaintiff's counsel said, is that an objection? What would you do?
I don't think plaintiff's counsel should have even said that. I mean, right off the bat, she's inviting argument. She's asking for colloquy.
I think there's something that should have happened several days before this deposition, and that is that you should know who your opponent is, know your judge, and know something about your client. And what I mean by that is, first about this opponent. If she ever came up before him before, then she knows and is accustomed to some of his tricks. If she hasn't, she should talk to other lawyers in her office and find out about problems they may have had with this particular lawyer, how they try to solve those problems, ask at the Bar Association about this lawyer, other friends, and get as much information as you can about the lawyer. And with that information, she would have been better prepared, I think, for that deposition. She should also know what the judge does. If she knows she's going to have an S.O.B. to deal with, she should find out how that judge reacts to that kind of situation.
Are you talking about the judge being an S.O.B.?
No, I'm talking, well, that's possible. That's possible, but does a judge like motions to compel?
For the record, I've never met any. But
just in case,
yeah.
You'd want to find out if that judge encourages motions to compel. If you come into his courtroom and there is this kind of bickering back and forth, what is his usual reaction? Does he have a busy call so he doesn't give much time to these kind of things? He doesn't like discovery motions. Find out about your judge, because if in the deposition you say that you're going to bring it before the judge, you want to know something about that judge.
Let me stop you right there for a minute, because I think it's important to try to figure out tactics that make the S.O.B. litigator self-destruct just because of the docket pressures that are going on. I mean, Judge Buckmeyer, you sit in the second busiest United States District Court in the United States.
Correct.
And state court judges, before whom most lawyers practice most of the time, are even busier. And also they may have problems getting before them the last paper that was filed by lawyers and so on. So when you talk about focusing the attention of the judge, I guess you mean you're not going to be able to do that all the time, right?
Deal with realities, and my realities are, you may catch me at a 15-minute break. I'm in a long criminal trial. I'm trying to juggle the civil docket. I've got a TRO coming in, I know. Congress has just voted against my pay raise, so I'm not in a good mood, you know. But the practicalities are also that the S.O.B. litigators are known in the communities where they practice. Some of them are known outside those communities. I keep my list. Every judge I know keeps their list, either in writing or in their head. So if you're going to catch me during a 15-minute break, one way to say, or to my law clerks, you know, one way is to say, this is a lawyer involved. Indeed, the first thing I ask my law clerks when I come off a break, if they tell me there's a discovery problem, is to say what law firm's involved. And if I know it's one of the S.O.B. litigators, then I'm thinking in terms of I get them in at the end of the day, I get them in at 7:30 in the morning. You know, nobody can refuse to come in early in the morning with a conflict. So you've got to do something dramatic to get my attention. Otherwise, it goes on the stack of motions which are going to wait for a 20-day response.
Now, the second phase here, Mike, is you're talking about preparing. Have any of our panelists had experience in courts that have a standard policy similar to what's in the Manual for Complex Litigation, or some kind of standing order or a scheduling conference order that dictates the manner in which objections are to be made at depositions and dictates the conduct of counsel?
I've done that in cases, Mike, particularly one that I knew in advance was going to be lengthy, involving a good number of depositions and a lot of document production and testimony with respect to those documents. I have asked for the enactment by order of a rule similar to that adopted in the Eastern District of New York with respect to the conduct of lawyers and discovery of proceedings in general. Some of the provisions in that order are not unlike those provisions that you find in the Dondi decision, which is a part of the written materials here. It serves to remind everyone, including the sponsor of the order, that we are obligated to treat each other with civility, that we're obligated really to get along as pleasantly, perhaps we don't admire each other, but as pleasantly as possible so that we can get through a very trying process without an undue amount of acrimony and bickering, which really detracts from the thrust of what we're doing. But before we go on to another question, I wanted to ask Judge Buckmeyer, because I've heard this comment made not only by him but by other judges. I'm very busy. I have very little time for discovery matters, and I don't enjoy arbitrating bickering. So if you come to my court, you've got to do something dramatic to get my attention. Judge, what is it that is dramatic that gets your attention in a discovery dispute?
Well, I'm going to answer that backwards. You know, I have different kinds of motions. You got to realize that you're not the only motion that's coming in. And I have a blivet motion calendar. A blivet, Kurt Vonnegut describes as 2 pounds of manure in a 1 pound bag. And, you know, those are things that don't take any time at all. You know, but you got to realize that there are tremendous mass of business for me to do in a limited amount of time. Now, if you were coming in to ask me to enter that standard order, I'll give you an example. All you have to do is come in and say, Judge, the opening question, the opening statement by me in that deposition was, if you don't understand the question, tell me, and then show me what happened, and I'm going to enter it. I don't need to go further on that. So that's a dramatic change. You know, and despite your comment on the sexist remarks, you may get my attention on that if the attorney has made some sexist remarks.
I might bring them to your attention if I got in on a motion, but I'm saying I wouldn't argue. I wouldn't bring them.
Well, I agree that you don't.
Dan was saying she wouldn't argue at the time, and that brings me to the last topic. It seems to me to consider, although we'll have to come back to it, and we will come back to it. Self-defense in the deposition being the first line of offense, because you're never sure you're going to get in front of a judge who will listen. Is what you're saying that to formulate your questions, to have them in mind, and to say to the opposing lawyer, are you finished? And when that lawyer is finished, then to put the next question.
You mean should you push on through?
Yes, push on through.
Of course you should. You take it as far as you can, unless the lawyer gets up and walks out or says, my client and I are leaving because your questions are meaningless, in which case you can't do anything to prevent a walkout.
But I think you push through, but you get an answer to every question. I don't think you should, if you ask a question and it's a good question in your mind, don't be afraid of that S.O.B. as she was in this situation. Stick with your question and get an answer to every question. Yes. I think it protects your record as well.
All right, now, the general rule is that unless there is an instruction not to answer, which under the rules of civil procedure, as pointed out in Steve and Chris Pickering's materials, can only be very rarely, you're entitled to an answer unless there's an instruction not to answer, right?
Right.
So that when you get the objection, the thing to do is to say, all right, answer my question. Well, I see Judge Parker out in Marshall, Texas, tells lawyers, well, you may not be out of things to say, but you are out of time. We're out of time. We've got to move on. Let's go with part 2 of the deposition.
Mr. Swain, calling your attention to Exhibit 20. Have you reviewed your file for any of the documents described in this exhibit?
Well, counsel, hasn't he answered that question?
No, he has not.
Can I take a time out on this, please?
Sure, absolutely. If you want to talk...
Do you understand the question?
Yes, I understand the question.
He wants to talk with his lawyer.
There is a question pending. It is not proper for consultation with counsel if he understands the question, and he does understand it.
Listen here. He wants to consult with his lawyer before he responds. Now, I didn't prod him. I don't know what he's got. But apparently he has a question, and I'm not letting you deprive him of due process.
I'm asking the witness to respond to a pending question before he talks to his lawyer.
Okay. I'll make it easy for you. You decide. Do you want to suspend? You can end it here right now. Take your ball home and cry. Or do you want the witness to have his moment of privacy with his lawyer? Or just move on to another question and stop wasting time?
I'll move on when he answers the pending question and not before.
Okay, miss, I've given you your choices. If you're not willing to go forward, I'll assume you want to suspend.
So I'm sitting there, feeling like an idiot, wondering why I went to law school in the first place, sort of hoping that this bozo wouldn't come back. Unfortunately, they came back in after a few minutes. God knows what they did in the hallway, probably developed new and improved techniques of perjury. So I carried on as if nothing had happened.
Mr. Swain, did you maintain the memoranda referred to in Exhibit 20 in your files at or about the time those memoranda were written?
What's this business of these memoranda? Why are we spending time on this? Why?
Counsel, I am not going to discuss my case strategy with you.
I only wanted to know because your whole line of questioning is absolutely ridiculous. After a few years in this business, you'll see that you are wasting everybody's time going into these minutiae. Why did your firm send such an inexperienced lawyer to take this deposition? We should have finished hours ago. You're just riding the meter on this one, lady.
These are proper questions, and they are directed to the discovery of important and relevant...
Don't give me that. I was taking depositions when you were running around in diapers.
I'll ignore that comment. Mr. Swain, did you have a conversation about this lease with Mr. Jones?
Donna, you've gone over this before. Go on to something else.
I don't believe I have.
Don't lie to me, little lady. You covered the same ground with Jones last week. I didn't understand it then, and I don't understand it now. Don't you have better things to do than to waste my time asking questions that are going nowhere? I'll tell you what. Let's break for lunch, and maybe you can organize your questions in some logical order.
Mike Hyman did not get a chance to give us the third element of his line of defense against the S.O.B. litigator. So let's start with that before we move on.
I think the third thing that the lawyer should have done before this deposition in advance is had to talk to her client, because what is happening here? What is the objective of the S.O.B.? There could be several objectives besides just intimidation and making her job much more difficult. It's going to cost more money, because if this happens, the deposition is now going to be elongated. The transcript is going to be an inch thick, and maybe if they could have finished in a couple hours, now it's taking all day. That's going to cost money, and I think you need your client to know that up front and find out from your client if you have a certain strategy you're going to use. If he can't afford that or she can't afford that, you better know that up front. And also is the time factor. When this type of activity happens, it delays the proceedings. We stretch the proceedings on for months. And that is something that you should make your client aware of in front.
Judge Buckmeyer, I'd like to start with you on this part of the issue. We've seen here an egregious example of coaching, right? And we watched the lawyer try to deal with that. What could she have done better?
On the coaching?
Yes, sir.
Well, I come back to don't meet that type of conduct in kind. I think she needed to relax just going through with the deposition. And I emphasize again that she needs to think not just about being before a judge on that conduct, whether coaching or the witness doesn't understand simple words, but think that she's looking toward trial. In my estimation, that conduct means that the settlement value of that lawsuit went considerably down because of the conduct of the S.O.B. attorney. If you notice in what she said, that was the second deposition. She had taken one earlier. One, I think, in terms of having a videotape so that the jury could dramatically see what happened. And then just to illustrate, you put the witness on and ask the witness, do you understand the term real estate? The witness is either going to look silly in front of the jury or say, yes, I do. And then you play the videotape. And, I can't speak for most judges, but with conduct like this, I certainly would allow that at a trial because it goes directly to the credibility of the witness. And, no attorney would act like that in court. Juries would be totally offended. and they would be offended at the performance of that attorney also on the videotape.
I'm sorry.
How would you respond to a motion after a deposition like that, to a motion having to enter an order that all depositions be taken before a magistrate or a special master, and perhaps the offending party to pay the cost of the special master?
Yeah, I think that's certainly one thing to ask for. I would respond favorably, seeing the history of that. And I'm presuming the same thing happened at the first deposition. If you give me a pattern and then come in and say, discovery is going to be horrible in this case, we need a master, and the reason it's horrible is the S.O.B., and make the S.O.B. and the client pay for it.
Your Honor, there was in the Middle District, I think, of Maryland, there was a judge who imposed a $5 fine every time somebody interrupted another person at the deposition. And then for discussion of objections and so forth, $5 per line. And then a master would go through the transcript and assert the fines accordingly. What about something like that?
Well, I think judges can be imaginative on sanctions. One of my problems with sanctions, frankly, Rule 11 sanctions, it's additional work that I've got to do, satellite litigation. And candidly, the S.O.B. that you saw in that videotape couldn't care less about being sanctioned in terms of me giving you attorney's fees for that deposition. That's cost of doing business. They're simply doing that knowing that and telling their clients, presumably, that that means that we're going to expect some sanctions, but we're going to delay, we're going to hide the ball.
In a big case, in any case, what you're suggesting is that early on, as soon as the pattern starts to emerge, you get before the judge and try to have something corrective, prophylactic done that's going to help in the long term. And in a big case, you might even ask the judge to have the clients in so that they can hear from the judge the adverse impact on their case of their lawyer's behavior.
That's the most effective sanction I've found recently, following the Dondi opinion, which I hope everybody reads very closely if they're going to practice in the Northern District. Following Dondi, one of the things I did in discovery disputes was have parties come in early, and then in a couple of really bad situations where both lawyers were at fault, said you bring your client. And I guess not surprisingly, they didn't want their clients to hear me say to them directly about how much money and how much waste of time those lawyers were costing them in handling that litigation.
Judge?
And so I had no further discovery problems in those cases.
Judge, were those clients also the deponents?
Now, in neither instance was that true.
Have you had that experience, bringing the proposed opponent in, or the proponent whose deposition was disrupted along with the lawyer?
I have not thought of that, but I'm going to put that on my list because I think that's a good idea.
Steve, let me ask you about all the S.O.B.s aren't discovered defending depositions. There are a few that take depositions. And I think we've all been in a situation in which the party taking the deposition of somebody identified with your client decides to sit there and dribble it out with a lot of meaningless, marginally relevant questions.
Just grinding on.
Yes. Under the rule, as you point out in the materials that you and Christina Pickering did, you have to hesitate before instructing not to answer, and yet you've got to exercise some ball control. Otherwise, your time and your client's money are going to be chewed up by that kind of conduct. What do you do about it?
Well, Mike, you've got to have a predicate to adjourn the deposition under 30D and get the judge's attention on a motion to terminate or limit or set time limits for the deposition. And for that reason, you've got to let the conduct you're talking about go on a little bit so that you do have the adequate record, that you can go to Judge Buckmeyer and say, look, Your Honor, here are 40 pages. You don't have to read them, but the same subject is being addressed in these 40 pages.
In other words, here are 40 pages. I defy the other side to find, for Your Honor, 2 relevant questions in there.
Sure. But let's come back to this scenario we just had here, the vignette. This fellow now has taken or has appeared in 2 depositions. He apparently has been obstreperous and obstructive in both. His conduct here, at least to me, is patently offensive. It's aggressively so. I think in addition to pushing on with the deposition, I might try at some time during the course of it, particularly where we took this last break, to stand up and call the judge or the magistrate or discovery commissioner, if that's the appropriate office to deal with on disputes like this, to see if I can get some assistance right then. It won't hurt anything. If you can't reach the judge or the magistrate, you can go back to the table and push on with the questions. But in addition to that, when I concluded that deposition, I'd take a look at the ethical dimension of it. In addition to the federal rules or state rules of civil procedure, what was the ethical propriety of that conduct? And should it go unremarked on if you can't get into court with motion practice or you can't reach the judge or magistrate by phone? In my opinion, it shouldn't. If you have the model rules of professional conduct in effect in your jurisdiction or some similar rules or the disciplinary code, the predecessor of the model rules, you can refer this sort of conduct to the appropriate state bar disciplinary agencies. And I assure you, as we point out in some of the materials that are part of this booklet, that disciplinary agencies are looking at these things now. Lawyers have a duty to cooperate with one another in expediting litigation. They have a duty to be courteous to one another, and that's what the Dondi rules address. Those are also enshrined in the rules of professional conduct. And if we're to live by them, we should also enforce them when they're not lived up to by others.
Calling the judge, that's your ultimate weapon. And it seems to me that you don't ever bluff it. If you say you're going to call the judge and he meets that, you call. And I think too often, though, an attorney will say, I'm going to call the judge, and they don't. And I think that's even worse.
Now, before calling the judge, you've got to have a very good idea of what you're going to say when the judge, who has a 15-minute recess in a long trial, answers the phone if you should be that lucky, right? Now, in the vignette we've just seen, Diane, what are going to be your first 20 words to the judge?
Well, I'd hate to see, I think, personally, I'd hate to see somebody call the judge in that vignette because I think, as I said, she was proceeding perhaps not in the best manner either, but I think the point at which he insisted on conferring with his client while a question was pending, I think that's the kind of immediate thing that might grab the judge's attention. I don't think you can call a judge and say, well, he's not behaving right or he's being an obstructionist. Or the judge can't rule in a vacuum. He needs a specific thing brought to his
Behaving right
attention.
Obstructionists don't convey any information to somebody at the other end of the phone.
That's correct. If you got me on the phone, good luck on that. I'm going to say file a motion, and we'll deal with it just like we regularly do. But you do have to give me some background. And I repeat again, I see so many motions to compel or motions for protective order that are a foot and a half high, and you don't need to do that. As a matter of fact, that's self-defeating. If you give me 3 pages with punchy examples of what happened, then that has a greater impact on me because I will read that.
Would it make a difference to you if the deposition is taken out of town and you call in, as opposed to something locally? Locally, you can go in later, you have time, you can always get the witness back. But if you're out of town, it's very expensive to go back, and that's more often you're going to call when you're in a situation where you can't come back.
True. And then I think you've got to lay the predicate. If you know or suspect you're going to have trouble, you need to contact the judge's office, contact the magistrate's office, and get ready so that somebody will be available to answer.
What happened to the cases pending in another jurisdiction, but the subpoena was issued out of your court, and somebody calls you? Is that handled any differently?
No. I think chances are you're going to the magistrate on that situation. And we've been talking in terms of judges handle these. Of course, the real world is that the magistrates primarily handle the discovery disputes. Except I think and I hope that judges are becoming more concerned at practices of S.O.Bs and that they're saying to themselves, like the Northern District did in Dondi, we're not going to put up with it anymore. And, Dondi reads well, but for it to mean anything, the judges have to be serious, and they have to stand behind it.
So that in bar associations, lawyers should try to do something about getting some ground rules laid. But now let's go back and just make sure that we're clear about what we just saw. That lawyer should have done what when the opposing counsel said, I want to leave the room? Diane?
Well, I think you have to put an objection on the record to him leaving the room. She can't physically restrain him from leaving the room. She then has to decide at that point whether she wants to adjourn the deposition and call the judge, or whether she's going to continue with the deposition and at some point later bring the conduct to the attention of the court. I mean, the important thing, I guess, that we have to keep in mind is that The purpose of the deposition is to get information. If the deposition is being conducted in such a way that there is absolutely no information forthcoming, then perhaps she's better off to adjourn the deposition. You have to be a little careful with the rules. In the materials that Steve has prepared, you'll see that the rules all go toward protecting the deponent. It's you file a motion to adjourn a deposition because somebody's harassing the deponent. In this case, somebody's interfering with the deposition but not harassing the deponent. Nonetheless, I think she should be prepared to make a decision to adjourn the deposition, but I don't think she can stop him from conferring with his client. I mean, there's just no way she can physically do that.
Well, as Judge Parker said, and I'm sorry, Steve, we're out of time. We've got to move on. And I think at this point we move to our next vignette, the Discovery Conference.
Dealing with that man was a nightmare. He was about as responsive as a brick wall. I had to serve 10 interrogatories just to identify the basic witnesses and documents. First, he tells me that he needs more time, so we agree to an additional 45 days. No problem. 6 weeks later, he files boilerplate objections to everything right out of the form book. He didn't even try to respond. I don't think he bothered to read the interrogatories. He was just playing for time. The local rules require a conference to resolve our discovery dispute, so we met to try to work it out. Listen, I want you to know that I was more than a little annoyed at your client's response to my interrogatories and production requests. You asked me for a 45-day extension on those, and I gave it to you because you said your client was real busy and needed the time to carefully consider the requests. And then what do I get? Not one response and not a single document, just a bunch of boilerplate objections. When am I going to get the information?
Calm down. Those production requests were garbage. Impossible to understand, irrelevant, immaterial, and unduly burdensome. How could I give you answers the way they were drafted?
You know very well that under the rules you are required to produce the documents that you don't object to and to answer the interrogatories to the extent you can. And state your objection.
I couldn't answer them the way they were drafted, period. And I'll tell you something else. If you expect any information, we're going to have to sit down right now and work something out to come up with some manageable discovery.
Well, that's not a burden I should have to put up with at this point. But let's see if we can make some progress today.
All right. Let's look at number 1.
Okay. It reads, identify each person known to the defendant who participated in negotiations leading up to the sale identified on Exhibit A to the complaint. What's wrong with that?
It's too broad. I mean, what do you mean by defendant?
Why don't you look it up in blacks, under D?
Oh, wise guy. Our defendant's a large corporation. How can I tell you who is known to a corporation with a dozen branch offices? And look at this. What is participated? That's just a very broad gauge word.
Sir, the question is straightforward and basic. It's your job to interview the people who work for your client and find out who's involved.
It's unduly burdensome. But here's what we can do. I'll ask the president, Mr. Jones, and the vice president, Ms. Smith, if they know who was involved. And I'll look at their files for a period of 3 months before the sale took place. Anything else is too burdensome.
These negotiations went on over 9 months, and people were involved at levels far lower than the president and vice president. I'm entitled to the identity of all the people who participated in these negotiations.
3 months. The president and vice president, take it or leave it.
Boy, okay. Let me think for a minute. Okay. In order to get the ball rolling, I'll agree to your limitations, only for an initial response without prejudice to my right to seek more information in the future. Understand? I'm not waiving additional discovery.
Sure, it's fair enough. I'll accept your offer. And let's look at number 2.
Well, it dragged on and on. We had to wrestle over each and every interrogatory and document request. A couple of days later, the jerk sends me this confirmation letter listing the agreements made at the discovery conference. You won't believe this. Interrogatory number 1. It is agreed that defendant's obligation to respond shall be limited to interviewing President Jones and searching his files for 1 month prior to the execution of the sales contract. That was not what we agreed. And it gets worse. plaintiff agrees that defendant will have no further obligation to make additional searches at any time in the future in return for its agreement to provide an answer to interrogatory number 1. I don't know what meeting this guy attended. I certainly wasn't there. But he got the upper hand by putting his version in writing first. Next time, I won't be so gullible.
Well, gullibility is the name of the game, isn't it? There's an Irish song that goes, "The minstrel boy to the war has gone. In the ranks of death you'll find him. His father's sword he is girded on, and his wild harp slung behind him." Well, Steve Morris, before the minstrel boy or minstrel girl in your office goes off to that meeting, what weapons would you suggest they have with them when they go to confront this S.O.B., and how would you suggest they deploy those weapons at that conference?
Well, I think before the conference he should have entered into something in the way of either an agreement or confirmed by letter what the extension of time was that he was granting. This started out with a request for an extension of time within which to respond to discovery, and then an assent to that, and then a response that was just boilerplate objections, and then a useless conference. You know before you go to the conference, in a case like that, where you've given additional time for someone to review documents and provide answers, who then doesn't do it.
But now you've got to nail that S.O.B. down and put yourself in a position that you can move to compel if that's what you're going to do.
Sure, and you've got to have a record of the conference you have with that S.O.B.
How do you make the record?
You have a court reporter present, and as you go through these items, you reduce to written form right then and there. What your agreements
you can't
are.
wait. You can't wait to get in with your.
Well, I think that you have to keep a log, and that log with an S.O.B. starts right at the beginning of the case. I mean, months ago, should have a log of every conversation you have, when it occurred, what was said on every telephone call. All your correspondence is kept. Things that he might say that you want to keep and use later before the judge. And by keeping a log like that, it's going to come in very handy later on if you do move to compel.
Okay, we've got the log, but here this vignette starts with those folks confronting each other in the office. Lawyer picks up the first interrogatory, said, all right, here's the first interrogatory.
But his mistake here was that the lawyer left the deposition without the agreement in writing. He could have made the notes. You don't even need a court reporter.
He left the conference without an agreement in writing.
He should have had taken notes himself. He doesn't need a court reporter. It's cheaper. You can just take the notes, and you agree on the language, and you both sign it before you leave, or have it typed up by a secretary, or have a videotape or an audio tape.
So it's like the old lesson when you first got appointed to a criminal case. They said, don't ever go interview those witnesses all by yourself. The first mistake was to go alone, because at the very least you need someone there to be the scrivener, to reduce each notion to writing.
Or you can do it yourself.
All right, and that is, here's interrogatory number 1. What is your objection? It is too broad. Okay, objected to as too broad. That's your position? Okay, that's right. Or let's modify it. What is the modification? We write that out. Diane, what else can we do?
Well, before we move on to what else we can do, I think it's appropriate to note that in some cases they just aren't large enough to justify or to afford carrying the weight of a court reporter, and there are a lot of sole practitioners in the world who don't have the luxury of being able to take other people with them. So I think, to the extent that the court reporter and the associates and so forth work in the right case, they're good suggestions. But if we can't do that, then we should try to memorialize it immediately ourselves, so we don't fall into the trap that he fell into. Now, with respect to the substance of the negotiation, this lawyer was in a sense bargaining against himself. He had a legitimate question. He had a right. It was a proper question. He had a right to insist on the answer. I don't think there was any particular reason for him to cave on that. He knew he was going to have to end up in court on a motion to compel anyway, the way this discovery conference was going. So I think you have to be reasonable in these sessions, but you don't, as I said, have to negotiate against yourself. And the specific one I'm referring to is when he asked him a simple thing, identify the witnesses. And this lawyer refused. Well, at that point, I think he's better off with an objection than he is with this giving away, his right to an answer.
In other words, the first thing is when the defendant's counsel says too broad, what do you mean by defendant? That's the time, whether you're by yourself or not, to say, all right, let's understand your objection because we need to litigate about this. Your objection is that you don't understand the term defendant. Is that it? Or is that too broad or whatever? The laptop computer can often be a good thing to sit there and memorialize these things as they happen, by the way, in this modern age. And I agree with you, Diane, that often, I mean, most of the cases in this country that are litigated don't have the kind of money involved in them that permits you to have all the, you know, court reporters and maybe even not to have an associate or a paralegal, somebody to go along with you. We've got to have tactics that, you know, things you can do by yourself, as Boys Life magazine used to say.
One other thing the attorney should have done after getting the incorrect letter, there's no excuse for not responding and putting the record straight, so that if you do get in a battle before the court, you've got your position back to them in writing saying this was not our agreement.
And I think it's important to note that the techniques we're talking about here are applicable not simply to discussions about interrogatories. In criminal cases, on bill of particulars and discovery requests, on any matter that you want to narrow or that you're required by local rules to confer about before presenting to the court, you want to make sure that you've got the other side pre-committed to their position so that there can be no mistake about what their objection was and what their position was when you litigated.
It may be appropriate, too, for the panelists to address the issue of using interrogatories, period. They are, in a small case, the kind of case that we were talking about, sometimes they're the only affordable sort of discovery that you can use, but lawyers have a tendency, I think, and I probably we're all guilty here at this table, to craft them in not perhaps the best fashion. If we could write like we were writing perhaps an elementary text, you know, right. Simple words, simple English, one phrase questions, identify, identify, identify. As soon as you get into an interrogatory that requires a narrative answer, it seems to me you know the lawyer's going to be writing the answer, not the client, and you may not be, and you may be inviting, perhaps unwittingly.
We're all victimized by this increasing practice in big litigation of serving mountains of interrogatories when something else would be just as inexpensive and more productive, right?
Fortunately, many courts have local rules that limit the number of interrogatories.
To 20, including subparts, for example.
Yep.
I mean, that was done in the corrugated box multi-district litigation. It's done by local rule in many courts. It appears to work pretty well, doesn't it, Judge?
Yeah. But where they're not limited, if you come before me on a dispute about answers to interrogatories, the first thing I'm going to do is see how many you served. And if you serve 300 interrogatories on the other side, you're already a loser. You're just not going to convince me that you're acting in good faith when you serve 300 interrogatories.
Steve, in a complex case where, I mean, look, whether it's a small case or a large case or whatever, every decision you make is an investment decision. How much of the client's money should you be spending to get where you need to get? What would you use, if anything, in preference to interrogatories to try to get a handle on the case in your first wave?
I might use a 30B6 deposition if it's a corporate party.
In other words, notice the deposition, ask him to bring documents with him.
Either ask them to bring documents with them or identify the specific subject or subject areas on which information is requested. Ask the other side to designate an appropriate spokesperson for that entity or that client to testify on that. So you can cut through the mountain of misinformation that Diane refers to, and I agree. We often get when we craft even the best of interrogatories. If you get a narrative answer back, for the most part, the answer is not useful. And if you go in and then go to Judge Buckmeyer or somebody else in motion practice, you've taken time, you've expended the money. Perhaps you could have better spent the time and spent less money by taking a deposition.
You know, a lot of time is spent just fighting over definitions a lot. And you have to be careful about definitions, and some courts even have local rules regarding definitions now to eliminate those type of problems.
Well, you know, one of the things that appears to be, this is the third or fourth vignette that we've seen, and in every single one of these cases, much of the wound that the lawyer who's complaining about the S.O.B. suffers is a self-inflicted wound. It comes from lack of preparation. So that, I mean, is it true that in every case you need to ask yourself, how am I going to find out the facts I need to be able to talk to 12? And Judge Buckmeyer, I wish it was 12 every time in civil cases. We don't need to get into that.
Well,
I agree with that. I agree with that.
To talk to 12 people about the case at the end. Is that the advice, Steve?
What you're saying is, wouldn't you profitably spend some time thinking out what it is you need and how to go about getting it, so that if you're going to send out written discovery, whether it be interrogatories or request for the production of documents in connection with a custodial deposition, that your inquiry is fact-specific, that it's directed, so that it is, to the least extent possible, subject to dispute.
So
you know what's relevant.
When you formulate your request, you save yourself a lot of problems down the road by taking the time at the beginning to make sure that it's narrowly tailored to your purposes, right?
That's right. I agree with that.
Now, Diane, you're a lead counsel in some of the most significant class action cases going on in the United States. At the beginning of the case, when for your plaintiff class you're formulating a discovery plan, how do you anticipate what the S.O.Bs that might be lurking out there in the bushes might try to do to you?
Oh, I know it by heart. I know what they're going to do. They're going to load us up with as many documents as they can possibly load us up with, so that it will make it as expensive as possible to find the information that we need, or to decrease the likelihood that we will find the information. The tactic of loading people with documents, I think we all, in a sense, invite, because perhaps we ask for too many documents. On the other hand, a Rule 33 response in a big, complex case is really to the advantage of the defendants, because they give you everything they can, or in this case, they're defendants, they give you everything they can possibly give you, warehouses full of documents, literally. So you know that is going to happen, and I think you just, proceed with the expectation that it's going to happen. There isn't much you can do about it. We do try more and more to avoid a lot of useless interrogatories, because you get very little information, and I think probably not just in complex cases, but in just, many, and not just in class action cases, but in most cases, you get very, very little information that's worth using. The biggest advantage that perhaps of an interrogatory is that may direct you in the direction of finding information, but they're not of much use, and maybe identifying deponents. There are two things about interrogatories that I thought would be helpful to mention. Some state jurisdictions have interrogatories that have been adopted by the courts, and in a particular kind of case, an auto accident case or something like that, there's a form set of interrogatories. You can't object to those interrogatories. They've been adopted by the courts, and they require you to answer. You answer the interrogatory, and you attach any document you used in preparing your answer to the interrogatory. And it eliminates a lot of the nonsense that we're talking about here today. And if courts would more favorably look upon, and bar associations look upon, promulgating standard sets of interrogatories for standard cases, I think they might be helpful.
That would help. And Judge Buckmeyer, we've talked about how to protect yourself once the damage happens. But in your court, for example, can a lawyer, suppose it's a case of a mail truck ran into somebody's car, so it's a $20,000 in specials, but it's under the Federal Tort Claims Act, it has to be in your court. Can I, as the plaintiff's lawyer that doesn't want to spend untold sums to litigate against some assistant U.S. attorney who's an institutional litigator and doesn't keep time like I have to, can I get from you some guidance to the other side about how the discovery is going to take place?
Yeah.
How do I do it?
Well, in my situation, I use a scheduling order, and if I've got a simple case like you've just described, then I'll set that on a fast track docket. I'm counting that there's not going to be much discovery, maybe none, and that any discovery in your hypo would be from the government and would be of the people involved. So you can get ready to go to trial in 6 months.
Well, as your colleague, Judge Parker, out in Marshall, Texas said, I'm sorry, we're out of time. We've got to move on now to something else, but fortunately, we all get a 5-minute break, and so do the people who are watching. We'll be back in a minute. Well, I'm Mike Tiger. That's no surprise to you. I'm not William F. Buckley, Jr. We're back again after that break with Judge Jerry Buckmeyer, Diane Nast, Steve Morris, and Mike Hyman, and we're ready for our next vignette, the motion to compel.
It's tough enough when you have to deal with an S.O.B. as opposing counsel, but when you have an overworked judge who's less than fair...
Good morning, gentlemen. Good morning, Your Honor.
Good morning, Your Honor. David Goodman on plaintiff's motion to compel answers to its interrogatories and production requests. Your Honor, although these interrogatories and requests were filed over 90 days ago, we have yet to receive a meaningful response from the defendant. In fact, Your Honor, defendant's only response has been to file boilerplate objections. In good faith, I have attempted to resolve these objections, But as of this date, defendant has failed to respond in a satisfactory fashion.
Counsel?
Your Honor, we've bent over backwards to expedite discovery in this case. I can't see how counsel can even suggest that we've been the least bit dilatory. Upon my urging, I set up a meeting with plaintiff's counsel, and I thought our differences were resolved at that time. Mr. Goodman agreed during the meeting to narrow the scope of his overly broad interrogatories and document requests. But after the meeting, he reneged on his agreement.
Your Honor.
Now, just a moment, Mr. Goodman. You'll get your chance.
I don't know what more I can do. I even produced the corporate vice president for deposition on very short notice just to placate plaintiff.
Your Honor, counsel is entirely mischaracterizing what has taken place. Defendant completely failed to respond to my discovery requests. When we met and tried to work things out, counsel insisted on an unreasonably narrow interpretation of my request. Then counsel attempted to
Why can't you two work this out? The call is very busy today. I don't have time to get involved in disputes over every single little interrogatory. Now, counsel says that your requests are very broad and that he's tried to work things out, but that you're being unreasonable.
With all due respect, Your Honor, take a look at interrogatory number 1 as an example of what
Mr. Goodman, I just don't have time to get into this today. Work it out. If you can't, then come back in. But don't waste the court's time on matters like this. And Mr. Goodman, a piece of advice. As you will no doubt learn when you have a little more experience, when you make an agreement, you have to stick with it.
Well, I remember my first argument in federal court on a motion call. I was 30 seconds into it, and the judge leaned over and said, "How many motions do you have today?" I said, "Well, I have 4 applications, Your Honor." He said, "Denied, denied, denied, denied." Now, Judge Buckmeyer, I haven't described you or anybody remotely like you, so could you start by telling us how you'd handle a hearing like that in your court, and then could you give us some advice about some of your hypothetical colleagues?
Well, I'll be candid. I probably, with that argument, would have done the very same thing that judge did. Very poor presentation. Again, you've got to catch my attention. Don't give me legal mumbo-jumbo, wasting time. Why don't you come at me and say, this is Rambo litigation. The defendant says he doesn't even know what defendant means. The negotiations went over 9 months, and they want to give me 3 months of discovery. Bang, bang, you've got my attention, and the burden's on the other side.
So that in a motion call of that kind, in a busy court, the most you can expect is 2 or 3 minutes within which you've got to get your attention, or you're dead.
Yeah,
right?
That's true. That's true.
The judge is saying you got to come right to the point and in a hurry. And the examples and the way he expressed them, I think, in terms of this vignette, are very good. This doesn't have any life to it. It doesn't have any assertiveness to it. The judge doesn't know why the lawyer is there. You know when a discovery dispute is on calendar, if you're a judge, that one side is saying, I'm entitled to some information, and the other side says they've got it or I've done everything I can to produce it. Right. And that's the setting for this vignette. That lawyer who wanted the information neither came to the point nor was aggressive.
And when he tried to do it, he did it too late. The old adage about put your best case up front, and then if it's if you don't need any other case, stop there. And that's what he should have done when he started out, instead of waiting. But Judge, let me give you an example. By then, he was dead. He lost already. I think the other question that might be considered is, did he belong in there on a motion to compel at all?
Well, that's really the question, because suppose that the court's response to discovery disputes is not at all sympathetic. Suppose you're in a jurisdiction or in front of a judge who simply doesn't want to hear about it, either because the local lawyer is not on the judge's list, and so the judge really isn't prepared to believe that lawyer would misbehave, or for any other reason. Not suggesting for a moment it's an improper one, but there you are and you're stuck there. What do you do, Diane?
Well, first of all, I guess we've got to look at what we've been talking about somewhat this morning. What kind of case is it? In a big case, a case where the expense will justify it, there are a lot of other ways of getting the information that he was trying to get, ways that may end up being onerous to his opposing counsel, for example, if he wants to know who participated in the negotiations and the fellow doesn't want to answer in the interrogatory, ask somebody in a deposition, file a Rule 30 notice and have somebody produced who can discuss the negotiations. Those tactics or those techniques, they're not tactics, they're fine in a case that can afford it. In a small case...
Even where you can't afford it, by the way, in the District of Columbia for many years, there's been a practice in indigent cases or civil liberties cases that judges will permit depositions to be taken with a tape recorder provided by the lawyers, and you can get an order that permits that. So there are devices you can use to cut the expense even of expensive discovery devices. But I'm sorry.
And if that's the case, then that may well be the answer to the problem. But it seems to me that those would be more appropriate ways to get that information at that point in that litigation with those players rather than to put yourself before the judge. The problem, I think, comes in again when you have a small case, a fender bender case, or a $10,000 or $15,000 maximum federal torts claim case, where you're talking about running up thousands of dollars of deposition transcripts. You really need to get this discovery in some other way. And then I guess that returns us to the fact that you're going to have to go in on a motion, but at least you've got to do it effectively.
There's something you can do. I think Federal Rules of Civil Procedure provide a mechanism under 26F. That is, they have a discovery conference with a judge. You draft the motion for the discovery conference, you meet with the other side, and at that conference you try to identify the issues with the judge, you set scheduling, and that way the judge will be brought up to date on what's been happening in this litigation, if it's taking place now in the middle of the
Mike,
case.
when do you do the discovery conference?
You should do it in the front end. You should
All
do
right,
it
before we ever
possible.
get to that, in other words, this motion to compel is 2 steps down the road from where you should have been. You should have done what Judge Buckmeyer finished just before the break with, that is right at the get-go had the judge set up a schedule.
Well,
Steve?
Mike, another point illustrated by this vignette is one that we touched on in the preceding 2 discussions, and that is you're in court before a judge, and I'm saying it's so, and the other side saying it isn't so. There's no record of what's been done. There isn't any letter of confirmation with respect to the extension of time. There isn't any record, whether it's handwritten, taken by a court reporter, recorded, or in another form, of what was agreed to between the lawyers at the conference. And the judge's parting shot to the lawyer on the downside of this was, next time you make an agreement, stick to it. Well, where is that agreement? You shouldn't have gone into that courtroom in the absence of any documentation at all.
The motion call is not a place to resolve credibility contests about who did what to whom and when. Is that right, Judge Buckmeyer?
That's absolutely right.
You're looking for some bit of evidence, that is the reduction to writing of what was agreed to at the conference, or a written statement of position that you can key off of, or that your law clerks can look at and help you. Do you have a bench memo when you go on a motion calendar? Or?
No, I just work off of the brief and the motion. But I wouldn't have filed a motion to compel in that case. One of the things I look at is what are they trying to get? And in this scenario, I say, well, the plaintiff knows who he negotiated with. The names are there. So why am I in the middle of an interrogatory, answer this interrogatory dispute? You've got before me, and you've taken your shot. You should have saved it for something that was more meaningful. Like Mike was saying, stack the deposition, stack the interrogatories, and come into me and say, this can't continue. And we've got to have a discovery conference, and we've got to lay things out. We've got to get a master appointed if it's that bad, and use those examples to convince me to do that, which then takes care of your problem or give you a mechanism for the rest of the lawsuit.
Before the break, Diane was talking about Federal Rule 33B, and I wonder if this isn't the point to talk about crafting your discovery to make it S.O.B. proof by...
Impossible.
Well,
can't do it.
Well, we can try to do that, and I thought that was the direction Diane was heading, to talk about seeking to minimize the use of sort of open-ended interrogatories, which is the answers to which are going to be drafted by lawyers anyway, and using interrogatories limited to a few basic facts, but really encouraging the other side to respond by producing relevant documents in response. Was that where you were headed, or if not,
Michael, I was.
tell us where.
I think the consensus of your panelists, judging from the nod of the heads and the chuckles, was that it's impossible to totally avoid the S.O.B. obstructionist discovery technique. But having said that, what I was referring to in the Rule 33 response was when you ask an interrogatory, and instead of providing an answer to your interrogatory, in the federal court someone would respond by saying that the documents would be produced which would contain the information. The test being, is the burden the same on one party as is it on the other,
right,
to get out the information? That used to be abused more than it is now. Prior to the amendments to the rules. The amendments to the rules now provide that if you are going to use that kind of a response, and there are comparable provisions in state courts, if you are going to use that kind of response, you have to label or identify in some manner those documents that are being produced to say, these documents are being produced in response to interrogatory 26 or whatever it may be, or alternatively you can produce the documents in the manner in which they are kept in the ordinary course of business. Those protections, those safeguards, if they are observed, work. They are, I find, observed more in the breach than actually in practice, and it is one of the things that you can pretty effectively negotiate a response for. Or, I think if you bring it to the attention of the judge, the rule is pretty clear. There isn't any flexibility on it. You have to do it when you produce documents that way. But I find very frequently, especially in these massive cases, that it's not done until counsel insists on it being done. You rarely have to end up in court about it, but it is supposed to be done, and it is supposed to cut down that looking for the needle in the haystack.
Right.
I don't know if it cuts it down. It makes it, maybe your search is shortened by a day or two.
So that you're putting it, the other side in the position of either answering or of producing the documents,
Right.
and if you don't get either one, you're more likely to get the judge's attention. And there, at least, with respect to document production, there is, I think, the built-in protection that if the document production is incomplete or dishonest, that's going to backfire on the producer, and as the case moves along.
Mike, it's worth pointing out that a response to 33C has got to be business records. It's not transcripts from related preliminary injunction hearings or testimony in a related or another case. It's not briefs or statements of facts and points and authorities that you've prepared that cover the subject. It's the records of the client you represent or that you're opposing if you're requesting from the opposing side. It's those records, those business records that have to be produced. And if there's an index to them, that's got to be produced along with it. And that subject is covered in some detail in the written materials for this presentation. But that's worthwhile observing. It's not acceptable for someone just to tender to you a mountain of business records and say, look, it's just as burdensome for me as it is for you to find the information here, dig through it.
The moral, so one moral, and I guess we're repeating this, is that the motion to compel really is a last resort, and that planning your discovery in a way that minimizes the need to resort to the court is a very important consideration, whether you do it under some local practice, whether you get a scheduling order or whatever else you get.
You can wear out your welcome in court very quickly if on the second day of discovery you're into Judge Buckmeyer saying, I need your help, and you're back there every week.
Right?
Going back to the hearing, and you have a judge who won't help at all. In even the discovery conference, nothing helps him. Here you have a judge, he won't give you a special master, nothing. Every time you go in, you're getting hit by the judge, you're getting hit by the S.O.B. What do? You have nothing. Nobody's helping you. I think one thing you could do is, in many jurisdictions, there are committees of bar associations that deal with complaints against other lawyers, against judges. And it's all done confidentially. Even if he finds out who has done it, it might be worth it to meet with those committees.
Doesn't the committee of that kind in Chicago have more important things to deal with than discovery disputes?
This isn't a discovery dispute when we're talking about the S.O.B.'s tactics.
Okay.
And we're only talking about his tactics, not the discovery dispute per se.
No, but the serious thing is, can you get a bar committee to look at that seriously?
I think if people begin to do it.
But again, you've got the same problem that we have here in this deposition or in this motion to compel. If the record of alleged misconduct is no more focused than this lawyer made in that conference, where he didn't take notes,
right,
or in this proceeding before the judge,
you have to have your record. Right? You have to have your record.
Yeah, they'll find it frivolous otherwise.
Now, do you think, Judge Buckmeyer, in the cases that you see, that lawyers do too damn much discovery anyway?
Oh, sure. Yeah, I think it's a sign of the time. They're afraid not to. You know, if a deposition can be taken, it will be taken. And, surprisingly, I don't have people coming before me very often asking to limit the number of depositions. And, that can be done easily in connection with a discovery conference.
Isn't that, after all, one response, particularly in the smaller case, where the value of the case simply doesn't warrant going out and discovering everything in sight and deposing everybody in sight, is to say to the opponent the S.O.B. who has managed to escape the just punishment of discovery sanctions through various devices, perhaps through the opponent's own ineptitude or for whatever reason, all right, why don't we go to trial?
Yeah.
Let's get a trial date.
That's the ultimate sanction against the S.O.B. litigator. You know, I'm convinced the ones I've seen really don't try cases. They don't know how to. And if they get in a courtroom and act like an S.O.B., the jury knows they're S.O.B.s, and they don't like that. And they're going to lose. And the response to the judge who doesn't get incensed, you know, by the motion to compel is also, you know, go to trial. And with what you've got here, with the deposition, and if you force the person to file objections to those interrogatories, you're then in a position to impeach the witness, and I mean impeach the witness in spades. Witness credibility is going to be 0 before 12 people, or 6 people.
Now, of course, that luxury doesn't pertain when the discovery that you need is of a crucial out-of-town witness who's going to be beyond the subpoena power of the court and whose testimony is simply vital to your case. I'm sure there are lawyers out there who would ask us the question, now, wait a minute. I understand all of this stuff, but what about the witness in Connecticut, and I'm in California, and I just need that deposition? How do I go about resisting the tactics of the S.O.B. litigator who's willing to outspend me?
Yeah. You've got to come before me, and you've got to get my attention. You've got to recognize the practicalities. You don't come in on that motion to compel on interrogatories. You save it for then. And you come in with examples that you can convince me that this is not just a routine discovery dispute. This is not one lawyer saying, well, they didn't answer my interrogatories right, and the other side saying, well, they didn't answer mine right. You know, those are not what we're talking about. You convince me that we're dealing with a Rambo S.O.B. litigator, and then I'm going to listen. And fortunately, there are not that many of them in my district, but you know, they are on my list. And if you hit a name on my list, well, then you're going to get my attention. And
that list is not in the materials that have been distributed.
No, it is not. It is not. It's confidential. But I've often, all of us have seen product liability cases where the expert witness just gets crucified because you do homework and you know the cases that person has appeared on. And I don't know why lawyers don't share information. I know they do. Why don't they keep their own S.O.B. list so that when they come before me on one of these really serious things, they can say, well, this is a pattern. Look what this same person did in another case.
There's another thing lawyers should keep in mind when dealing with the S.O.B., and that is egos. S.O.Bs usually have extremely big egos. And I think too much in litigation.
Unlike other
lawyers. Well, that's the problem. You got egos against egos. And if you're being hit with this S.O.B. on the other side, you don't have to scream and holler in return. You're not a wimp. You're going to do a lot better for your client if you don't elongate everything, if you don't have to file motions and everything. I think you have to try to act as you should act as a reasonable person because somebody else isn't acting right. That doesn't mean that you have to also roll in the mud.
Let me underscore that. You know, if you're going to be before me, if you're going to be before a jury, don't get down in the gutter. You know, don't argue back on depositions. Don't do the same thing on interrogatories. You know, if you come in, you know, even though you may think you'd get a short-term gain by lambasting the attorney or doing the same sleazy tactics, you're going to be in the same position before me as that person.
You don't think they're a wimp because they don't do that?
Oh, absolutely not.
Well, as Judge Parker said, again, we are not out of things to say about this, although we are out of time. One of the things that folks might consider in their communities is having the local bar publications do a Jerk of the Month club with some transcripts of S.O.B. behavior for all to see. It's a matter of public record, and it can be done. Maybe we'll consider that suggestion a little bit earlier. For right now, I'm told we have to roll our next vignette, Rumors in Discovery.
I was defending this high-profile firm. Breach of contract. It was a real beaut. A big dollar case, bitterly contested from day one. 2 years of discovery. We deposed anything that moved. Left no stone unturned on this one. Well, I knew opposing counsel was tough. His firm has a reputation for hardball. But I didn't think he would punch below the belt. Let me tell you what this joker tried to pull. Right after this smoker was filed, we go in on a preliminary injunction. I call in one of my guy's executives to testify, a Mr. Anders. Okay, Anders is sworn, he tells his story, and he tells it straight. The other side doesn't contest his testimony at all. There's nothing in the record which contradicts Anders. The guy told the absolute truth, no doubt about it. A year after the hearing ends, Anders finds a better job with another construction company and moves on. As luck would have it, plaintiff's counsel, that S.O.B, bumps into Anders' new boss.
Jill?
Harry.
Listen, I hear you folks just hired a guy named Anders.
That's right. Got him about 6 months ago. He's a great guy. He's doing a wonderful job. Do you know him?
Unfortunately, I do.
Is there a problem?
I don't like to talk about these things.
Harry, if there's something going on.
All right, but it's got to be off the record.
Of course.
Well, I heard through the grapevine that Anders was fired from his last job. Something about perjury in an evidentiary hearing. Got his boss in big trouble. They canned him.
Boy, that's a surprise. He doesn't appear to be the type. But maybe I better check it out.
Well, after hearing that story, Anders' boss makes a few calls to check it out, including a call to my client. Word gets back to Anders, and he's worried about losing his job over this crazy lawsuit. And it gets worse. My client, the contractor, mentions the unusual phone call to plaintiff's counsel, the S.O.B who started the damn rumor. He denies everything, of course. Then the S.O.B files a motion to compel the production of employment records of Anders and certain past and present employees of my client. Boy, was I mad.
Your Honor, my client has heard from very reliable sources that the defendant's employee, Mr. Anders, was fired for committing perjury in this case.
Counsel?
Your Honor, that statement is absolutely untrue. Mr. Anders did not commit perjury in this case or any other case, and thus could not have been fired for that reason. These employment records are highly personal and contain confidential information. Opposing counsel is making wild statements and accusations, all unfounded, in a desperate attempt to convince this court to turn over these employment records. Counsel knows very well that these records are irrelevant to any issue before this court.
Your Honor, the only way to get to the bottom of this matter is to have the defendant turn over the very records which will show us why Mr. Anders' employment was terminated.
So, how do you deal with a person like that? First, he plants a false rumor to create a bogus issue in discovery so he can obtain otherwise confidential records. Not only that, the rumor intimidates my witness who's afraid of losing his job. How can I protect myself and my client from this kind of dirty trick?
Well, there you have it. The oldest lawyer trick in the books, well, at least as old as the first day I ever started practicing law in Washington, D.C. Putting the other side on the defensive by making them object to the production of something and try to make it appear that they're hiding the ball. Steve Morris, suppose we could back that tape up to the point where the judge turns to the so-called victim and says, "Counsel, and you're the counsel, what do you say about those employment records?"
Here they are, Judge. Take a look at them. There's nothing in there to be afraid of at all. Nothing in here to substantiate this unfounded rumor that my opponent apparently has engendered just to throw this case off track. Nothing. Turn them over. Give them to the judge. Let me take a look at them.
Judge Buckmeyer, you're nodding yes. You're the presiding judge. What are you going to do?
Absolutely. There's no reason to object in that situation. And, and don't change what you should be doing just out of common sense because you got an S.O.B on the other side. This one is easy. You either do, like Steve said, you get the judge to look at them in camera, or you just say, here they are. You can have them.
When you say, "Oh, Your Honor, this is absolutely not true. These records are irrelevant. Let me hang on to them. Let me keep them," you just sort of play into the hands of your opponent who's clamoring that you're trying to conceal something.
If you do have an objection, because the request is that employment records of other people be produced, or there may be some doctor, patient, or lawyer, client, or whatever it might be, then at the minimum, you want to give them to the judge for in-camera review to determine whether they should be produced. Diane Nast is saying no.
No, I agree. Once again, what I'm shaking my head about is that the S.O.B litigator here is not really the only guilty party. The lawyer, the supposed or so-called victim, set himself up for this by preparing improperly. And it seems to be a theme that's pretty pervasive, that when we conduct ourselves in ways that are less than proficient or technically competent or common sense-wise competent, that we invite the S.O.B. to retaliate. I have share your concern about the possible, doctor, client or some kind of privilege in the records, but that certainly wouldn't stop this guy from tendering these records to the judge.
There was a judge in Fort Worth, Texas, who, when I was a much younger lawyer than I am now, had occasion to admonish me in terms I think all lawyers should know. I kept being nervous about what I thought were the unfair tactics on the other side. And finally he looked over, he said, "Mr. Tiger," he says, "this is not a justice of the peace court in Dumas. This is a United States District Court. I will hear the evidence on both sides, and you will get a chance to put on your position, and then we will evaluate all of the evidence, and we'll figure it out. So why don't you sit in your chair and just pretend that there aren't quite so many springs in it as there are. Just be a little more comfortable." Is that what you're saying? That you got to let the process work itself out? Do that. Mike, let's take the next step. Suppose we do what Steve and Diane and Judge Buckmeyer say. We produce the employment records.
To the judge.
To the judge. They get turned over to the other side, and now the case moves along. Let's go ahead and play the next couple of hands in this to show how you're going to put it to the S.O.B. that started the problem for you. What are you going to do?
One thing I would consider doing is if the S.O.B. continued to plow too,
Right.
I ask for a protective order. And
Okay, turn them over under a protective order. They cannot be used except for the narrow purposes for which counsel said they were relevant, i.e. to impeach the witness. Good. Next.
sometimes it may help to try to reason with the jerk. I wouldn't rule that out altogether. Again, I'm going back to the egos. If you treat somebody decently, maybe eventually you're going to get through to them. I think a lot of these problems happen in large cities because lawyers don't know other lawyers. And it's often a complex case, or any kind of case. The lawyer on the other side, you may never practice again in any case in your lifetime against him. So he doesn't care about you, and you don't care about him. But that's the wrong way to do it. I think you should be civil and courteous with lawyers and eventually become their friend. Right. Maybe he's going to change his ways.
Michael, there's another fundamental question I think that we ought to address. Assuming that the hearing was handled properly or improperly, it's over, as you say. After that, what, if anything, are we going to do to get to the bottom of this rumor? And what should we do, to defend our client?
You are the victim of a rumor in discovery. Now, the first step is don't permit yourself to be put in that box. Michael Hyman's suggestion about a protective order is very important. I mean, it seems to me you got to make sure that if you're going to make a production to somebody, anybody, S.O.B. or not, that there be those kinds of limitations. Now, the next step is, what do we do? You think you're the victim of this sort of rumor mill, or you're the victim of some misconduct. What are you going to do about it? When the hearing is over, Diane, what specifically do we do?
Well, depending on what it is, and I think in this case it's a matter of some consequence, because you may end up with chilling the testimony of a very important witness. Assuming that you make a decision that it is a matter of more consequence than just the tactics of an opposing counsel that you're dealing with, then I think you have to undertake an investigation. What the parameters of that investigation will be will differ from case to case. Here, I think you may want to take some depositions.
Well, you've got this fellow Anders, right? Anders is somebody that you're going to need as a trial witness at some point, or maybe you're in trial right now, and Anders starts saying, wait a minute, I didn't exactly bargain that I was going to have to fade this kind of heat, and I got to tell you that, my memory's not getting so good, and I'm just, it's a real problem for me, and I really wish you wouldn't, and all of those signs that the witness is backing away from you. And so you've got to do something to protect that witness from that behavior. We as lawyers, we're used to this, but witnesses who begin to see that bad things are happening to them because of their identification with one side or another begin to have some real human problems. What are we going to do to protect Anders? We're going to talk to him first and say, hey, look, we're going to get to the bottom of this and find out where this started. Then how are we going to do that?
I'm not sure you just want to talk to Anders. I think you may want to depose the, for example, the woman and find out where she heard got this information. Let me see what Steve would be.
Sure,
Well,
Steve?
I want to do some investigation, and if I've got some leads to follow as a result of that and can take a deposition or two, like Diane suggests, that would substantiate that my opponent was engaging in that sort of conduct, I may want to do two or more things. Number one, if I substantiate that my opponent has planted that rumor, I want to go in and tell the judge about it. Number two, I probably want to file a complaint with the Bar Association.
Well, let's stop right there for a minute, because isn't it clear to everybody that if you've got a good investigator available to you who can go out and conduct some interviews as a kind of start, or if you can otherwise prove that this happened, then that's a home run, isn't it?
Oh, yeah.
If you can prove that your opponent did it, that's it. Case is over.
Right.
And so that it's important to try to get at this information as quickly as possible. My own experience says that most lawyers that are in regular trial practice have investigators in whose judgment they have confidence. You want to put that person out on the street and try to backtrack this thing and then take the next step of discovery afterwards.
Yeah. Let me go back to the hearing.
Sure.
Because you can start there. You can do something very simple. In addition to handing the judge the personnel file, you can say, no, this is a very serious matter to us. We have to find out whether this rumor is true or not. And we think it's incumbent upon the opposition to come forward and tell you, Judge, where the rumor came from. Right. And you either got the person saying, I'm not going to divulge it, for some reason, and the judge is not going to be very happy about that. Or he gives you the name of the lady he talks to, and you can proceed to interview her or depose her.
On this vignette, though, the lawyer said, Your Honor, my client has heard. Well, I'd like to have the client come in then and say to me, if I was the judge, Your Honor, I heard this from my lawyer. And you may have hit the home run right there. On the other side.
So that in addition to the turnover and the protective order, right, if you have confidence that your position is just and right, which is the dominant assumption here, then you got to have the confidence to play the whole game, which includes producing those documents and then asking that in light of your forthcomingness that the next inning be played.
The other side reciprocate.
Right.
Yeah. Well, even if you're not right, you want to know. You want to be able to tell the judge, we have discovered that this witness committed perjury, because you want to get as far away from that witness as possible.
Exactly. So that
either way, you go.
You want to get to the bottom of it.
So, Judge Buckmeyer, you're saying that you really don't have anything to lose by marching forward here, and indeed you have a great deal to gain, because at the end of the day, in a situation like this, somebody is in big danger of wearing the hat of the spoliator.
Absolutely.
And you don't want it to be you.
Absolutely. Yeah.
Ultimately, that's where you got to be.
Yeah.
Well, we've got some questions from those that are listening in. I suppose there's a phone number on the screen or something like that. Those of us that are not familiar with this medium don't exactly understand how it works, except they hand us things. And I'm supposed to go to a question and answer session now, which means I have to put these on. Here is a question from Tulsa, Oklahoma, involving administrative agency practice. Typically, the commissioners do not hear cases de novo and are not lawyers. They rely on written reports from administrative law judges, and these reports in turn are the result of lengthy, factually difficult kinds of cases. And parties objecting to the conclusion of the written report can prepare a written appeal. Then you get an oral argument. In other words, by the time all the S.O.B. conduct has happened, it's been filtered, as I understand this question, through administrative law judges and rulings and so forth and so on, and now you've got a limited amount of time to argue to a commissioner. And let's make it concrete. You're saying that way back when, there was a very important item that was overlooked in the process. What do? Any administrative practitioners?
I'm not sure I understand what our question is, Mike. What do we do to bring a discovery, to focus a discovery dispute where you've got a record that is perhaps too big and unwieldy and unfocused?
Right. You get down to the end, That is, here you are at stage 5 of a long, complicated process. How do you get any redress from a discovery S.O.B. problem that took place at stage 1?
You made a mistake. That's what we said earlier. Don't wait. Right away, when it happens, you should get on it. In this case, I think that there's some discovery that the attorney needed, and the S.O.B. wouldn't give it to him. He just got to keep plugging. Don't give up.
Yeah. I would have to agree if I understand the question, because I don't want you in trial or at pretrial arguing about discovery things that happened a long time ago.
No.
If you're going to use them in trial, as I suggested earlier, that's one thing, but that's not what the question is.
I'm not sure I understand the question, but let me...
Is this an administrative fact-finding that culminates in a de novo court review, and at the de novo stage you find that your record is insufficient or that there was evidence that should have been discovered?
Under the Administrative Procedure Act or any other federal review, I don't think so. But I think that the answer we've given is adequate to the question. And that is that every case that I ever have, I try to get up in the morning, or at least a couple of times a week, I like to go back to it and say, when this case is argued to a jury, or when this case is argued to the commissioners, or when we get to the end, what am I going to need to say? How much more do I need to find out to verify so that what I say, when I sum up on it, is right and provable and demonstrable? Therefore, in the discovery phase, we go back to what we said in the very first panel. Don't let the S.O.B. get you off asking the next question, and the next question, and the next question, and the next question. Don't get mad. Get even. And get even by focusing on the result of the process, which is eventually try to persuade somebody of the rightness of your case. Is that...
It's interesting, Michael. I've heard that by some pretty, colorful and good litigators say that they write, the first thing they do in their case is they write their closing statement. Then they write their opening statement. Then they formulate their discovery. And
do you do that?
I don't know if I've written them, but I've outlined a few.
I'll tell you a good exercise to help formulate discovery. If you have a jury case, or even if you don't have a jury case, pretend that it is, and that is draft your jury instructions at the outset, or try to see what it is, what are the facts and the issues you want to present to them for a decision, so you can frame your discovery accordingly.
So the surest defense against the S.O.B. litigator is to have your own game plan and to execute on it.
Correct.
Because what that person wants to do is to use his or her ego to bounce you off what you think is the right way to conduct your litigation, right? It's an ego bump.
And don't let the egos get in the way.
Question. The discovery game usually occurs in 7 or so steps if the requesting party is an honorable lawyer. And then there are the 7 steps. You make requests, the other side comes back, you come back, and then there's a hearing. In other words, pretty much the scenario that we have encountered here. And result, it says, at the hearing, the judge or magistrate awards you 50 to 75% or so of the discovery to which you're legitimately entitled, usually the least useful 25 or 50% being included in that. How do you do with this litigator type, the dribbling litigator, who dribbles out discovery materials of significance only when the court forces him or her to do so? If the metaphor gives you trouble, you can forget it. But how do you deal with that?
I think you go back to 26F. You go back to the court for a conference, discovery conference, a pretrial conference. Get schedules. And if you have a schedule which says certain things to be produced at certain times, you're going to have all that worked out up front. Don't wait.
Steve?
I like that. And in addition, you ask the judge, if he goes along with you, you're in good shape. That if information on a particular topic or issue is not produced by such and such a time, then, or all that's prevalent, information on that topic cannot be subsequently produced. In an egregious case, you might even get an order precluding proof on an issue. If you have somebody just dribbling this out over time and the most significant occurs at or about the time you're ready to go to court.
And don't discount asking the judge to appoint a special master. If you've got a real S.O.B. on the other side and the problem is going to continue from deposition to deposition, get the court's attention and say, we know you don't have time listen to us week after week. We know the magistrates are busy. They don't have time. Let's get a special master and charge it, let the special master recommend who it's taxed against at the end of the discovery.
And another thing I think that ought to be mentioned, to the extent that you're able to convince a judge or a special master or a magistrate to rule without a big paper record, I think that's very helpful. If you can get somebody to sit down with you for half an hour, and say, all right, this is the question, you get the ruling. This is the question, you get the ruling. Without pages and pages and pages of briefs. I don't know what the judge thinks about that procedure. But even if you don't win every one, you got an answer. You can move forward with your case. You're not mired down in days and weeks of briefing.
What do you do when the S.O.B. is not, he's given you all the discovery. You're getting discovery. That's not the problem. The problem is he's like Morton Downey. I mean, you're going crazy. He's screaming and hollering. And he's just a very irritable person. Is there anything you can do with that kind of...
I don't think there's anything you can do to stop the person from behaving like Morton Downey. A couple of suggestions, concrete ones, have been made here. Think about spending the money to videotape a deposition so that you can show it to the court if necessary. And the next thing is that, yes, we've all been in a room with folks like that, and it is, are you done? My next question is, do you understand what is meant by the words real estate? Is that an objection? Are you telling the witness not to answer? He's not telling you not to answer. Please answer my question. In other words, that's going to be very hard on you, and when you're done, you're really going to want to bite the knobs off all the dresser drawers in your house. But that seems to be the way to do it. Yeah. Is that right?
And Mike, I would say, think about what you're going to do with that person when you're in trial. Yeah. And when you've got the jury sitting there watching. Now, if that person is acting like an S.O.B., you're not going to get up and yell and scream back because you want the jury on your side. And that's exactly how you should act in a deposition.
But that's where videotapes in particular can be very helpful.
That is, I guess that's a lesson as old as the first martyrs in recorded history, right? Who thought about the better life to come. You being martyred there in the well of the deposition, think about the trial and the revenge that you're to wreak, not in the next life, but in this one. I guess that's, maybe it's good. We've got another question.
Well, you probably got people out there thinking, that sounds great, but what do I say to my client? Because my client is sitting there watching me take this. Well, let me suggest what you say to your client is that S.O.B. is going to be before Judge Buckmeyer again. Don't worry about that, because that's not a winning game. That's a losing game. And let me tell you how we're going to approach the lawsuit. It's not going to be a Rambo S.O.B. We're going to get things done with courtesy, with cooperation. Your bill is going to be less. And any client likes to hear that the bill is going to be less.
You could also quote Cicero, who in 59 BC said that if you have a weak case, abuse the opponent.
We have one more question, but it's such a good one that I'm going to save it until after the break, because I think in a little while I'm going to have to take a break. I want to emphasize something and take the prerogative of summing up here for a second. In the old days, when lawyers all knew each other and the bar was smaller, many of the things we're talking about could be handled informally. Today, however, you ought to consider that we need rules. And maybe in your jurisdiction there aren't standard discovery orders. Maybe in your jurisdiction there aren't scheduling conferences. Maybe there aren't standard interrogatories. It's up to lawyers, therefore, to organize. Don't mourn, organize, as Joe Hill said the night before he was executed. Get out there and move the bar to lobby the courts to put in place the defenses against S.O.B. litigators. That, after all, is going to solve a lot of the problems we're talking about by a sort of preventive process. We are about to conclude the first half of this program, but please come back after a 20-minute break. When you do come back, some people will be missing so that we can get some more on here. So we want to take this opportunity to say a special thanks to Steve Morris and Michael Hyman and Diane Nast. Judge Buckmeyer, you and I will be back here with 3 more gladiators in a bit.